Our case for today is Vicente del Rosario versus People. The facts of the case are the following. The PNP received report that Vicente del Rosario was in possession of certain firearms without the necessary licenses. The PNP Firearms and Explosives Division issued a certification that Vicente Vic del Rosario from Bicte, Norzagaray is not a licensed firearm holder. By virtue of a search warrant, the PNP went to and searched Del Rosario's residence. The PNP seized a 45 caliber pistol and ammunition from Del Rosario's bedroom, a 22 caliber revolver from a drawer, and an Armalite rifle magazine and a two-way radio from his daughter's bedroom. Before the regional trial court, Del Rosario was charged with violation of illegal possession of firearms. Del Rosario averred that his 45 caliber pistol was licensed and denied possession of everything else. The RTC convicted Del Rosario. On appeal, the Court of Appeals affirmed the RTC decision, hence the present petition. The issues which the Supreme Court held to resolve were 1. Whether Del Rosario had a license for the 45 caliber pistol, and 2. Whether the 22 caliber revolver, the Armalite rifle, and two-way radios were illegally seized. On the first issue, the Supreme Court held that in the positive, stating that the PNP Firearm and Explosives Division certification referred to Vicente Vic del Rosario from Bicte, Norzagaray, and not to Vicente del Rosario from Tigbe, Norzagaray. Bicte and Tigbe are two different barangays. Hence, the certification does not refer to the petitioner. Del Rosario was able to present his license to the PNP. However, the PNP said it was expired. Assuming the license was expired, still, possession of firearm was not illegal. The firearm was kept at home, not carried outside the residence. At the time of the seizure of the firearm, possession of firearm with an expired license was not considered unlawful, provided that the license had not been cancelled or revoked. RA 8294, providing that the possession of a firearm with an expired license was unlawful, took effect only on July 7, 1997. It could not be given retroactive effect. Under the firearm licensing regulations, the renewal of a firearm license was automatically applied for upon payment of the license fees for the renewal period. The expired license was not cancelled or revoked. It served as a temporary authority to possess the firearm until the renewed license was issued. Meanwhile, the applicant was not obliged to surrender the weapon. Del Rosario paid the license fees for the automatic renewal of the firearm license for the next 2 years upon expiration of the license in January 17, 1995. In fact, Del Rosario issued a renewed license on January 17, 1997 for the succeeding 2-year period. Further, the PNP chief issued Del Rosario a permit to carry firearm outside residence valid until January 25, 1996. The said permit presupposes that the person upon whom it was issued is duly licensed to possess the firearm. On the second issue, the Supreme Court held that in the affirmative, stating that they were not included in the items to be seized in the search warrant, nor were they in plain view of the PNP. Del Rosario rejected the firearm as planted and not belonged to him. The kind of possession punishable under PD 1866 is one where the accused possessed a firearm either physically or constructively with animus possidendi or intention to possess the same. In the absence of animus possidendi, the possessor of a firearm incurs no criminal liability.